So following on Bill, I'll ask Anna to take over and knit some of this together.
Well, first of all, I am deeply grateful to Adam and to the Institute, to Adam for his generous, incredibly overly generous introduction and your hospitality. And it is absolutely humbling to be here on at this table with Bill and Jeremy. So I'm grateful, humbled, and as Jeremy said earlier, you know, correctly insecure. Now, another reason for humility is that I am a lawyer, so I have absolutely nothing to say on subjects like debt sustainability, but for any law students in the room, there will be a pop quiz on the model that Dr. Klein just put up. You have 2 days to study it up. Radio. Now, although our primary topic is Europe, I am glad that Bill mentioned Argentina, which used to be the focus of sovereign debt happenings and is migrating back into the spotlight where Europe has held court since 2010. We are, and I don't think it's much of an exaggeration, living through something of a revolution in the legal regime for sovereign debt management that may rival what happened in this world in the 80s and 90s when much of the law was made. And that is not only or even primarily on account of the Second Circuit decision that we just heard about, which may or may not stick. But really in two places, in Europe and in New York/Argentina, we are seeing dramatic changes, ranging from the path-breaking restructuring by Greece, which you've heard about a bit, and I'm sure we'll talk about more, and then also a slew of contract and treaty reforms, at least designed to promote creditor collective action, affecting a class of government debt that is much, much bigger and more important in the global financial system than anything we had tinkered with before. As for Argentina, which is in its 12th year of default and litigation, we have had a ruling by the Court of Appeals for the Second Circuit endorsing a remedy that attempts to influence Argentina by targeting various intermediaries and market infrastructure, and that is really the bigger significance of the decision. So I will start with Europe, then talk a bit about Argentina, and then try to bring the two together, all very briefly. Now first, as for the Greek exchange, and here I commend a paper by Jeremy and colleagues called The Greek Exchange, an Autopsy, or some other colorful title like that, but definitely had something to do with dead people. Greece restructured a record volume of domestic law debt. Now this is not the first time we've had a domestic law debt restructuring, but most likely the first time when domestic law debt was the predominant concern. Arguable exception of Russia, but the scale is absolutely incomparable. This is the biggest and most comprehensive restructuring of this sort. And if you were to accept, BIS classifications, and I have no reason not to, this is the first time we have had a restructuring of developed country domestic debt, which is a near $40 trillion category, as compared to developing country foreign debt, which has been the focus of all the theory and conversation and is about $500 to $600 billion, right? That's TR and B, right? Trillion, billion. So we're playing in a completely different puddle, if you will, and it's one has to keep asking whether the models developed for one category should really hold for the other. Now, ironically, one notable legal feature of the Greek exchange was, of course, the move from domestic law to English law debt. The other was the use of domestic legislation to amend the terms of the debt retroactively across the board to enable creditor majorities to bind the minority, legislation that is misleadingly sometimes called, or often or always called the retroactive collective action clauses. We can return to that in the Q&A. Now, speaking of collective action clauses, Europe, of course, is also at the forefront of contract reform, and Adam referred to this in his introduction. Even before the Greek exchange, beginning in 2010, in fact, one of the earliest initiatives in response to the Greek crisis was a move by Eurozone officials to harmonize domestic bond documentation an initiative that is now enshrined in the ESM treaty, and includes a commitment to issue, starting this year, debt with standardized and identical collective action clauses, binding dissenting minority bondholders with a vote of the majority. Now, Netherlands, I think, was the first to go a few days ago. Now we have Spain, and we can expect other countries to go forward. From my perspective, this is significant not so much because of the introduction of collective action clauses. I'm on record as being fairly skeptical that as it stands, this reform will make a material difference in these countries' capacity to restructure one way or another. They're not bad, but they're not transformative in and of themselves. What is important, I think, about this initiative is the harmonization of contracts in a giant, taking back to trillions, right, and notoriously heterogeneous category of debt. Most government debt issued in this world is issued under domestic law, under documentation that is anything but standardized and very little read or understood and very often hard to find. So the fact that Europe is moving to standardize this and publish it and instead of having these public discussions about this is important to my mind. Another important element is the fact that this is treaty-driven reform in the context of a debate about a restructuring mechanism and loss distribution that is very self-consciously political. So if this is a beginning of contract harmonization and greater transparency in a $40 trillion world of domestic law debt, this is a big deal. If this is a sign of greater acceptance of treaty-based debt restructuring reform, albeit in Europe, which likes its treaties, but still, this is a big deal, okay? Editorials suggesting, I think correctly in my view, that Europe is positioned to lead on statutory bankruptcy, they're right, but the extent to which the rest of the world would be willing to follow, I think, is a very big question mark. But all in all, by sovereign debt standards, the Europe story is actually relatively optimistic, and I think it's mostly a reflection of the sorry standards of sovereign debt. Argentina is a whole other story in every way. In a ruling last February, a federal district court in New York said that Argentina violated a clause in its debt contracts which ostensibly promised equal treatment to the holders of its old defaulted debt and its new exchanged debt. And importantly, it also said that the remedy should include enjoining Argentina, prohibiting Argentina from paying its exchanged bonds unless it also pays proportionately to the defaulted bondholders, right, to the holdouts. Now, creditors have claimed, the holdout creditors have claimed, and the district court, Judge Grisey, agreed that entities in active concert or participation with Argentina, which includes the indentured trustee Bank of New York Mellon, DTCC, Euroclear, which is in Belgium, and the exchange bondholders, could be in contempt of court if they accept or process payments to the exchange bondholders. This is important because until this time, sovereign debt has been essentially unenforceable, right? It's pretty easy to get a judgment. It is virtually impossible to get paid. Now, what this does is it creates a business model where most people go into restructuring because their options otherwise are dismal. But the few remaining, if they have the resources and the commitment to stick it out for 10 years, could collect an outsize award. If this ruling stands, and it survived one round of appellate review in late October, and is back for another hearing in late February, sovereign debt becomes enforceable to a point, but not by sanctioning the debtor itself, which is still practically unreachable, but rather by the sheer breadth of the collateral damage it could inflict in the financial system, financial infrastructure, as well as what it does for the doctrine of sovereign immunity. Now, this is not a sky is falling argument. I just want to be clear. This is purely I don't know to what extent anybody will or wants to blow up the world. But mechanically, the remedy is you cannot reach Argentina, therefore you go for everybody else and hope that they make the debtor come to their senses, okay? Going forward, the choice then will no longer be whether to take a deep discount or to take a chance and hold out, right? But whether to take the discount plus be a defendant in litigation versus holding out. This does not mean holding out becomes more attractive. I absolutely buy the argument of the investors who say, look, the last thing we want to do is stay there for 10 years and hope that somebody is as outrageous as Argentina and the judge is as exasperated as Judge Grisey, right? But at the same time, what happens is participating becomes unattractive, right? And who will sign up to be an indentured trustee if that means a high likelihood of being a defendant in a litigation? And while Argentina is arguably unique by sovereign defaulter standards, and those are some pretty amazing standards, there's absolutely nothing in the opinion that says it's Argentina only, these are the 5 things, and everybody else can go free. The court had the option to limit its holding to something uniquely bad that Argentina did, this domestic legislation it passed. It didn't do it, it went much broader. Now no wonder then, because of the nature of this remedy, that you've had briefs from dozens and dozens of market participants on both sides, from American Bankers Association, amazingly siding with Argentina, New York Clearinghouse, same thing, retail bondholders siding with the holdouts, and the US government, in an interesting procedural move, also intervening both at the district court and, in the first round of appellate review and then again now. Now, arguments made to the effect that Argentina's clause is unusual and the growing prevalence of collective action clauses should make the problem go away, which we've seen in the Financial Times among other places, are missing the point. The pari passu, the equal treatment payment formulation that Argentina has, is increasingly common, and just for 2 absolutely random examples, Cyprus has an identical provision in its English law bonds, and Italy has one that's quite a bit more vulnerable than what Argentina had. Again, it doesn't mean that they're about to be sued, I'm just saying. Collective action clauses, what they do, and again, they're wonderful, so is vitamin C. And what they do is they reduce the number of holdouts left, but they do not affect the weapon that the holdouts remaining hold in their hands, okay? You can make a bond issue drop out of a restructuring, even with aggregation across different bond issues. Now, for one example from Jerriman's paper, less than half of Greece's foreign law bonds that contained collective action clauses actually went into the restructuring. I think they tried a vote in 36 and succeeded in 17, right? So you had about 6 billion euro in holdouts with collective action clauses. Transition will take time. Some bonds without collective action clauses are, decades out, but again, that argument I don't find particularly interesting. And perhaps the sleeper argument is there are instruments other than bonds that do not have collective action clauses and cannot readily be brought in that may be able to avail themselves of this remedy. Now, the big question, of course, and this is where we've seen a lot of editorializing, and I suspect we'll see more, would statutory bankruptcy help, and is Europe the start? To be sure, if a regime like the IMF's sovereign restructuring mechanism were there, and Argentina moved to restructure all of its debt under its procedures, the likelihood of holdouts would be dramatically lower, if close to nil. Whether that is worth the trouble and whether SDRM is the right regime, I think is something we can productively discuss in the Q&A and for weeks and months and years ahead. So thank you.
Thank you, Anna. I'm just saying, it's a phrase we don't hear here very much. It's good to have a lawyer.
That's what I went to law school for.
I do want to get to Miklius and others who want to ask questions or make comments, but let me just quickly circle back if Jerriman or Bill want to say something about the Argentina comparison. Yeah, Bill and then Jerriman.
Yeah, I guess I don't understand, Anna, your view that the CACs don't solve the problem. If I buy a bond that has a CAC I'd have no standing to complain and hold out if it meets the threshold and they say that this is now restructured. So unless you can convince me, I think that the CACs do solve the problem. Brazil is borrowing with CACs, or Mexico is borrowing with CACs. This is, I think, what it might suggest is that you want to set the CAC threshold at 70% instead of 93%, because in the instance of getting the threshold, you know, the holdout might be more of an issue. But I wonder if you could clarify why you don't think that the CAC basically addresses this.
Yeah, Anna, please.
Precisely for the reason you mentioned, right? And Greece is a perfect example. And query, how low do you want the thresholds to go? And would the optimal threshold depend on whether the pari passu remedy is available? At the moment, partly because of all the liability management, there are a lot of orphan bonds. Ooh, what happened? Orphan bonds, right? So small issues trading at a deep discount, where it takes a relatively small investment to make the bond drop out. And on a panel, I was on a panel a few days ago where a lawyer representing some of the holdouts in Greece said actually that CACs in that case made it easier to hold out because it gave them the roadmap for which issues, how much to buy. And so, you know, process works for both sides. If it's a predictable process, it's a predictable process for holdouts as well. I do not think there's anything at all wrong with holdouts. I think that it is the prerogative of voting creditors to keep their issue out of their restructuring. What I'm concerned about with the remedy is that this remedy targets everybody who goes in and therefore destabilizes, to my mind, leaves the outcome of the exchange uncertain.
So my main question is, again, to Anna is, so I haven't quite understood whether you think the sky is falling or not. Because on the one hand, you seem to say the sky is not falling. On the other hand, you say this is being drafted in a way that is completely general. So in my simple sort of economist mindset, they're essentially, you know, I am a potential holdout. I observe this judgment. So there are four interpretations. First, from the very innocuous, in the sense of the debt restructuring regime, to the absolutely catastrophic. The innocuous interpretation is, look, we always knew that holdouts would win with some probability. This is just one realization. But the actual, I don't need to revise my probability as a holdout that I might win, so my incentives don't change at all, okay? So this is absolutely no precedent whatsoever setting interpretation. The next interpretation is, look, the probability of winning as a holdout just went up, but it's still a lot below 1. That's kind of what you seem to be suggesting with this thing that is kind of still unattractive to hold out. Third interpretation is, you know, the probability of winning went up, and maybe on top of that, or alternatively, there is a certain class of debtor for which the probability of winning as a holdout is now equal to 1. So for those nasty debtors, they shouldn't even try to do orderly debt restructuring because it will never succeed. And then the fourth case is, this is such a strong precedent because it's so broadly drafted that after this moment, every judge, at least within the New York law perimeter, possibly even outside, is going to just cut that 10-year process short, and after 2 weeks decide that, you know, because Greece's arguments are so general, the holdouts always win. If it's the last thing, this is indeed the end of sovereign debt restructuring as we know it, and we need to pull out the big guns with, as I understand it, is either the SRM or some gigantic CAC with aggregation across all debt classes. So where, in which of these four categories are we?
I must say, I really like the idea of a gigantic. Okay. You know, I'm a lawyer. I'll never tell you yes or no, right? So, however, I have a really good reason not to tell you yes or no because this case is on appeal. And what happened was, so the judge issues his remedy. It gets appealed to the Second Circuit. On October 26th, the Second Circuit says, we think you got the interpretation of the clause right, but we want you to think about two more things. We want you to think about what exactly does proportional payment mean? Does it mean $1 to $1 or 100% owed, meaning an interest payment, to 100% owed, meaning full principal, accelerated, defaulted, penalties, et cetera, right? And number two, we'd like you to think about the breadth of the injunction. Does it reach bank intermediaries? Does it reach clearing systems? Does it reach exchange bondholders? Now, on the Wednesday before Thanksgiving, Judge Grisey did something that did not endear him to anybody, well, maybe not to the plaintiffs, yes. And he issues this ruling that basically says the answer is obvious. Proportional means they get 100% of what they're owed, meaning 100 million to 1.3 billion. And it applies to everybody, including, quote, clearing systems, unquote, right? Ignoring completely, as far as I could tell, letter from the New York Fed and various other submissions. The Second Circuit then did something very unusual. It stayed the application of the judge's order and said, you know what, we're ready to hear from everybody and their cousin. If you have something to say about this, we let you come in as an intervener, as an amicus, as a non-party appellant. And so what we have had is, just on January 4th, we had 17 briefs filed from all manner of interested parties. So that's why I actually don't know how this is going to come out. My prediction is that it will be very hard for the court to go back on the ruling altogether, but they could pare it back to the point where it's not much of a change to the status quo.